Thank you, and welcome back to our webcast viewers as well. It is my pleasure to now turn the podium over to Commissioner Noah Phillips for remarks.
Thank you for that. Good morning, everyone. Welcome back. Of course, what I'm about to say are my own views, not necessarily the views of my fellow commissioners or the commission as a whole. It's great to see such a level of interest in the future of the COPPA rule. This kind of stakeholder participation is a hallmark of FTC rulemaking in general, and your involvement in that is crucial. It's also a hallmark of the history of the COPPA legislation. In 1998, Senator Richard Bryan recognized the remarkable consensus that the House and Senate had achieved on COPPA, and the fact that that was due to the input of a broad set of stakeholders, noting that the revisions to the original bill were worked out carefully with the participation of the marketing and online industries, the Federal Trade Commission, privacy groups, and First Amendment organizations. Senator Bryan explained the goals of the legislation: to enhance parental involvement in children's online activities, to protect their privacy and safety, to maintain the security of personally identifiable information collected from children online, and to protect children's privacy by limiting the collection of personal information from children without parental consent. Senator Bryan also recognized that the interest in protecting children online was not without bounds, pointing out that legislation accomplished its goals in a manner that preserves the interactivity of children's experience on the internet and preserves children's access to information in this rich and valuable medium. Senator Bryan's remarks highlight an important concept. The American privacy framework is built on identifying risks and then designing a solution that balances competing interests. That requires evaluating the sensitivity of information involved and the potential harms that would result from its collection, use, or disclosure, and then creating a solution that will limit these harms while still allowing appropriate use of even sensitive information. With COPPA, rather than trying to protect children by limiting their experience on the internet, Congress instead created a comprehensive yet flexible framework to protect both children's privacy and their ability to access interactive content across the internet. Our American privacy framework recognizes the trade-offs at issue in the privacy debate, balancing privacy interests with innovation and competition, and protecting most the data considered to pose the greatest risk if shared or otherwise misused. This approach, like any other, is not infallible, and reevaluation and recalibration may at times be warranted in light of changed circumstances. Nevertheless, our risk-based framework has permitted innovation, competition, and economic growth for decades. In 1998, when Congress enacted COPPA, technology looked quite different. At that time, a major concern was that children were providing their personal information through website registration forms and surveys, or posting contact information on electronic bulletin boards. Unlike the phone ringing or the mail carrier arriving, parents could not observe these communications. The first three cases the FTC brought under the COPPA rule are illustrative. The girlslife.com website targeted girls aged 9 to 14 and offered features such as online articles and advice columns, contests, and pen pal opportunities. Partnering with bigmailbox.com and LookSmart, the Girls Life website also offered children free email accounts and online message boards. In these three cases, the FTC alleged that the defendants each collected children's names and home addresses, email addresses, and phone numbers. None of these websites posted privacy policies that complied with COPPA or obtained the required consent from parents before collecting this information. In 1998, social networks, smartphones, geolocation, and static IP addresses were barely on the horizon. However, by 2010, the FTC recognized that changes in the online environment, including children's use of mobile technology to access the internet, warranted another look at whether the rule was sufficient. In December 2012, after a thorough notice and comment process, the FTC announced amendments to the COPPA rule, which address changes to the technological landscape. Among other things, the amended rule updated the definition of personal information to include geolocation information, as well as photos, videos, and audio files that contain a child's image or voice. The amended rule was expanded to cover persistent identifiers that can recognize users over time and across different websites and online services, such as IP addresses and mobile device IDs. The amendments also made clear that the COPPA rule covered child-directed sites or services that integrate outside services, such as plugins or ad networks, that collect personal information from visitors. In addition, the amendments also clarified that if plugins or ad networks have actual knowledge that they are collecting personal information from a child-directed website or online service, they must also comply with the rule. As we consider whether COPPA needs further amendment, I would make 3 recommendations. First, in contemplating changes, we must keep in mind the original congressional intent behind COPPA. It would be easy to stray from that mandate, especially in these times, and to substitute our own preferences in the place of legislatures. Technology has evolved in ways unimaginable in 1998, but we need to ensure that any amendments to the rule are grounded in congressional intent. Second, any rulemaking must be grounded in facts and supported by data and empirical evidence, rather than just predicated on unsupported fear or speculation. Just because we are talking about privacy, or even just because we are talking about kids, more regulation is not necessarily better, including for kids. Finally, we should focus on the impact that conduct being or to be regulated actually has, and in particular, whether it causes harm. There are those who will tell you that we need to avoid using personal data at all costs, especially when it comes to children. And our children are indeed precious. And technology can indeed present risks, which makes it easy to scare all of us who care about children. But not all risks are the same, and not all harms are the same. The ability of a strange person to contact and communicate with a child is not the same as an advertisement appearing when a child is watching a show. We need to be able to recognize that. What is more, focusing entirely on the possibility of harm and discounting completely the potential promise of technologies seems the wrong course to me. Our approach should be one of taking care for children and for data both. For example, e-learning platforms can support teachers, students, and parents creating customized lesson plans or dynamically focusing on areas an individual student finds challenging. To do so, they need to use personal data. As much as a child's interest in online content or TV may sometimes frustrate me as a parent, and it does every weekend, every day, there is still great value in entertainment, and even in the advertising that pays for it. That's a value to parents and kids. COPPA is about empowering parents and protecting kids. We should keep that in mind. In doing, we should balance the risks and help children, parents, educators, and others understand them. We should recognize where data support new technologies that can be important public goods. And we should allow rulemaking to reflect the thoughtful process in which all of us are engaged today. Thank you all for your time, and I appreciate your participation in this process.
Hello. In case anyone missed the first panel, my name's Peter McGee from the FTC's Division of Privacy and Identity Protection. With me is Manisha Mithal, Associate Director of the Division. We're moderating the second panel this morning, which concerns the scope of the COPPA rule. Thanks to Commissioner Phillips for his remarks. And I will now introduce our panelists. Their bios are included in the materials, so we'll be brief. First, we have Perry Aftab, Executive Director, the Cyber Safe Group. Next, Malik Ducard, a Vice President of Content Partnership at YouTube. James Dunstan, who serves as General Counsel to Tech Freedom. Donna Frazier, Vice President of the Children's Advertising Review Unit. Josh Golan, Executive Director of the Campaign for a Commercial-Free Childhood. And Don McGowan, the Chief Legal Officer and Business Affairs of the Pokemon Company International. Again, we're hoping for a interactive dialogue among the panelists. So with that, I'll turn it over to my co-moderator.
Hi, thanks everybody for participating. So Peter and I are going to split up the panel. So for my part, I'm going to spend about half hour or so talking about an issue we touched on in the last panel, and that is the scope of the COPPA rule. I want to talk about both the directed to children side and the actual knowledge side. So as people know, you can be subject to COPPA in two ways. The first is if you're directed to kids, and the second is if you have actual knowledge that there's a kid on your site or service. So let's just start with the directed to kids test and do a little level setting as to kind of who is covered under the COPPA rule under the directed to kids test and who should be covered under the COPPA rule under the directed to kids test. So if you look at our rule, we list a number of factors for determining whether a site or service is directed to kids, including the subject matter of the site, the visual content, use of animated characters or child-oriented activities or incentives, music or other audio, age of models, celebrities, language, advertising, and any empirical evidence. So those are just some of the factors in the COPPA rule. And so I want to start by throwing open the question, are these the right factors? And regardless of whether they're the right factors or not, should some of them be weighted more heavily than others? So who wants to take that first?
Good morning. I think that we need to recognize that most of the industry these days, as opposed to 20 years ago, know who their audience is. And they're marketing to their audience, and they're monetizing their audience. They know exactly how old, or pretty much how old, their users are, and they're telling it to their ad agencies and people they're trying to promote and their investors. So I think that what we need to do is, we can look at the other older factors, but everything's musical and animated these days for all ages. And I think that perhaps we need to start looking at what the industry's telling others about what they know on their platforms, and perhaps maybe even so far as to require that once a year they notify the FTC with the percentage they believe are under the age of 13, and that might allow things to get in there.
And I'd just like to piggyback on that, because I think that, one of the things we hear is that it's so hard for operators to determine if their content is child-directed, but at the same time, we've had this huge scandal around advertisers being upset that their advertisements were being placed on inappropriate content, on white supremacist content, on things that they didn't want to be associated with. So we've had a whole move towards brand safety, and platforms giving advertisers assurances about where their ads are going to be placed. And as part of those assurances, they tell advertisers whether you're going to be reaching children or not. And so if the platforms are able to tell advertisers this, it seems to me that they're able to tell what's child-directed. And again, echoing a point that Laura Moy was making this morning, this seems like a excellent place for the Commission to use its 6B authority in order to understand more fully what the platforms are telling advertisers about what they know when there are children or there aren't children on their platforms.
So, Donna and then Malik.
So I'm not convinced that all content creators know precisely the age of their audience. I think that they may have a sense of who their target is, but I think that once they get out in the real world, what may have been originally perceived as mixed audience or for older children entices younger children. I don't think that a lot of companies are intentionally getting into the kid space knowing the vulnerabilities to that, knowing the liabilities of that. I think a lot of companies are being quite careful, and I'm a proponent of that. I think companies want to do the right thing. They don't always know what that is.
So actually, before we get to Malik, I want to just unpack what's been said so far. So I think there's been two threads. One is that companies know who their do companies know who their intended audience is? It sounds like yes. And then the other is, what is the actual audience? Where there's a disconnect between the two, is there one that should be weighted more than another? And Malik, I know you're going to answer the prior question, but I want to throw that out there. What matters more, the intent or the actual audience, or is it both, or does it continue to be a multi-factor test?
I mean, I think optics matter, right? And I think that the last few cases we've seen, both at KRU and I think at the FTC, it is an optics issue. Because what is perceived by the audience may not always be what the idea was behind the building and the creating of that content. And I think that there are ways to use other empirical evidence that other technologies and other self-regulatory and regulatory bodies are using with regards to media data and all that sort of stuff to determine who your audience is.
No, I would add that I think my answer covers both questions in a way. The COPPA factors that have been outlined, we really do believe that those are the right factors. But I think that what's really important is that there's balance of the factors between both content, whether it's subject matter or the content of, let's say, a video, and content. So audience and who you're advertising to and what the intent was. And having the right balance is important. We get concerned when one factor is looked at not in an inclusive way, but in an exclusive way. So audience, for example, with audience as the sole factor, we think that gets to a skewed reality. So you can imagine we're in World Series time right now. And if a popular sports game has a large amount of viewership on that, there's going to be a large amount of children who are watching that as well. Does then that make that match, that game, child-directed? And that's an area that we don't think it should go in that direction, but the proper balance is important. The second point I'd like to make is around clarity. So once you have that balance, we think that clarity to creators and to platforms on where the line is drawn between child-directed, mixed audience, general audience, that those lines are a little bit unclear, and there's a need for more guidance. So, as everyone knows, YouTube recently announced product changes that we'll be making in the next few months. When we announced those product changes, there was an overwhelming amount of request for clarity, confusion in the creator-developer landscape around where do I draw the line? Is my content child-directed or not? Or I believe my content is not child-directed, but I don't have enough clarity to really understand how I should be classifying that content. And I know that there's creators in the audience and a lot of creators watching this live stream right now because this is something that meaningfully impacts their lives. Some of the questions that came into my team include, for example, does describing content as family-friendly or kid-safe mean it would be classified as made for kids? If we just want to be clear that the video doesn't include swearing, does showing a child in the video mean it's made for kids? If I use an animated sequence for my cooking show, does that mean it's going to be defined as made for kids? And so on and so forth. So we think that clarity from the FTC in this process, which we're excited about, is helpful.
So it's interesting, and people should please put up their tents if they're interested in responding to a point. But I just, one thing, Malik, or does that, maybe it doesn't stand. Okay, I'll just take note.
They used to in the olden days
They used
before
to
you had
stand, right.
plastic, yeah.
So Malik said something very interesting. He said, on one hand, one factor shouldn't be dispositive, but on the other hand, there's a need for clarity. But aren't those two things at odds? So it would be much clearer if we said X percentage of kids are on your site, therefore you're kid-directed. So I just want to see if anybody would respond to that, but I saw that Josh and Donna had put up, and then James.
Who wants to go first?
It wasn't me.
Oh, okay. So I think that part of the confusion was properly displayed in the TikTok decision, right? So I think that TikTok proved that it's very difficult to determine who the targeted audience is, right? And with TikTok, we saw that there was evidence of a lot of preteens and teens and who appeal to younger children. So younger children always want to age up, right? They want to engage with that. But you also had a CEO who was out there talking about engaging the younger child audience, right? So there were a number of factors that still made it difficult to, I think, make the case that TikTok was directed to kids. So again, I think back to what Malik was saying, I think the clarity issue is one thing. And I don't think that there's a hard line. There's no silver bullet on this. But I think we have to figure out what the combination of factors are, and I think giving clarity to those specific factors are key. And many of those factors, I think, seem to be more helpful in, the post hoc evaluation of something as opposed to when you're building it out.
Josh? Sorry, okay.
So I want to springboard a little bit on what Malik said, and specifically the directed to that notes celebrities who appeal to children. Well, there are a lot of little kids out there who have baseball players and football player posters on there. Those are celebrities. Does that mean that all sports sites now are directed to children? I mean, I think that one in particular really needs, I think, some discussion, because you really run the risk of transforming a lot of truly general audience sites into kid sites if you just apply that as a celebrity, who appeals to children as somehow, and if you combine that with some mystical percentage of kids that you can think may actually be on the site. We run a real danger of, I think, being incredibly over-inclusive on sites that we would conclude are directed to kids.
Perry?
I think, and I'll address something James said, we have never, in the 20 years that COPPA's been out there, ever looked to the fact that there's a baseball or football player being used on a site and saying that it's therefore directed at children. It is, to use a quote from the U.S. Supreme Court, there's this penumbra of indicators as to whether you are child-directed or, and so what we need to do is do something with it. So the Cyber Safety Group is in the process of building, free, totally free, an app that will allow people to go in and indicate, what do you know about your users, all of the rest. I'm not collecting information from you, so I'm not going to tell the FTC, but do you have all of the factors that we would normally look at to help them find the clarity? And I welcome Google to help us play with that. As we help them understand where that definition is by seeing all of the different factors that come in saying, talk to a lawyer, but maybe you're child-directed.
Okay, Don?
I mean, the term is child-directed and not child-attractive, and I think that the intent of the statutory language has to be understood to mean something. Going back to what Commissioner Phillips said, we shouldn't substitute our judgment for Congress.
Okay. Okay, so we've talked about intent and audience composition. There's some factors that don't necessarily appear in the rule that we've seen throughout the years. Things like marketing tie-in of toys, the name of the site. So App Store categories is another one. So how should those factor in? Is that part of the calculus, or is that something that we should consider adding?
Go ahead.
I think all those factors absolutely should be factored in, and I think that, one of the things we've seen as a carryover, something that KRU has worked on extensively is the tie-ins with PG-13 movies that were then used to market an inappropriate movie content to a younger audience. And now we're seeing the same thing with, Angry Birds is a preschool media franchise. And so to say that that's a general audience app when you have or those are a family of general audience apps when you have a preschool movie franchise and toy franchise seems a little disingenuous. So I think, and the App Store categories certainly, give us all sorts of signals about what the intent is and what's going to be actually recommended to children. And as Dr. Rudetsky said this morning, also give us an intervention point where we don't have to deal with, 10,000 apps on an individual basis. So it seems to me that, that how these things are marketed, actually, if we're looking for factors to weigh a little bit more, how these things are marketed should be something we weigh more, but not just how an individual app or an individual video is marketed, but how franchise exercises are marketed, how associated toys are marketed, because those are all part of the ecosystem in which children are receiving information about what's appropriate, and parents are receiving information about what's appropriate for children.
So we have a great question that's just come in from the audience that I want to throw out there. And the question is, if it is unclear if an app or product is child-directed, what would be the harm of erring on the side of being directed to children and therefore covered by COPPA?
Yeah, I can jump in on that one, and yeah, I think it connects to something that Josh was saying as well. So we really believe that when you have an adult who is watching children's content and reasonable measures are taken to really identify that as an adult, that adult should be able to watch that content in a way that the adult is used to watching other content. And the reason I think that this is important is because there are many, many use cases. That this is not a small thing, but many use cases where adults legitimately watch content which might be deemed child-directed. So, for example, on YouTube, we have a category that is sort of falls into family vlogs and parent vlogs, and any given creator might in that category one day within a video talk about Halloween costumes and what's the family going to be doing in Halloween, and then in the next video or the same video talk about the top 10 tips for a safe Halloween, which may not be interesting to the kid, but will be interesting to the parents. And then clicking into that, the engagement that you lose when you move to a child-directed setting, like comments, and that sort of feedback loop goes away. And in the example that I'm sharing, parents are commenting to the video, to the creator, and there's a real back and forth feedback loop that is really central to digital and how so many of the platform operates today, especially YouTube.
Okay, and I think Don and then Josh.
I just want to leverage off something that Malik just mentioned, which is the idea of people over 13 who are watching content that you might think is targeted towards people under 13. If you represent a brand that's been around long enough, there'll always be adult fans who have a nostalgic good feeling about the content, and when it's made available to them, they'll watch it also. And I would say the idea of automatically treating that as child-directed just because it's something that we know is attractive to children. That's why I say directed versus attractive is a criterion to keep in mind. It's not YouTube's fault that a piece of child-directed content was uploaded on, or a piece of child-attractive content was uploaded on their site and was watched by a grown-up.
Josh?
And I would just say, if YouTube and Pokemon and other brands have evidence that adults are watching this content by themselves, then that's evidence that the commission should be getting, using its 6B authority and get information we should be getting from companies, because, with all due respect, I don't think we just want to take those companies for their word here today. I think we want to actually see what data they have in terms of individual adults without children watching children's content.
Donna?
So I want to go back just to a couple of comments before about the marketing to kids. And I think, at KRU, what we really look at is when something is advertised to a child during specific TV time, right? So I've seen content and marketing things for, let's take Fortnite. And it may be attractive to children. However, it's not being targeted to kids. It's not being sold during TV time. It's not being coupled with other things that would be attractive to kids. So we would never take the position that that was, directed to kids. We're not seeing it during TV time and things like that. And the other factor that I know gets talked about a lot and gets confused a lot is the issue of ratings in the App Store fronts, right? And the fact that these ratings are not about whether or not this is a privacy issue, whether or not data is collected. It's solely about the content of the product and the appropriateness, right? The ratings are really intended for a guide to parents. So I think that there's a conflation with regards to what that rating means and what it should be intended or interpreted to be. 4+ does not mean that it's, necessarily intended for a child audience. It's about appropriateness.
Okay. Jim?
Yeah, to answer your specific question, what's the harm of just treating them, as directed to children? It's very simple. I mean, we assume that much of the internet and much of the web that we see is going to be free. And the reason that it is free to us as consumers is because we pay a price in terms of being subjected to advertising. And we know that the numbers are and how we are monetized on our use of the web. And the fact of the matter is there is much less value in a website to a marketer that is directed to children because of all the restrictions, as Malik was talking to, and other restrictions as well. They simply do not want to advertise or are not willing to pay as much because the advertising is not worth as much money to them. And so the danger is you lose the monetization, and ultimately you lose content creators, you lose the incredible diversity we have of content on the internet if people can't make money out of creating it.
And Perry, I want to call on you, but so it seems like we're focused a lot on the advertising and the content. So there's a lot of discussion this morning about, a lot of COPPA is always focused on verifiable parental consent before collection. But there's a lot of other parts of COPPA. There's the data minimization, there's data security. Are the concerns about over-designating child-directed content, are those mainly about verifiable parental consent, or do they also include these other requirements in COPPA? And Perry, do you want to?
Yeah, I'll address that as part of my other comment. Attractive to children is very different from targeted at children. And at some point, those things that are attractive to children develop enough of a preteen audience that it flips the business model. And when we start recognizing that there's so many kids, now the company's going to respond to that, monetize it, deal with it, either try to keep the kids out or figure out how to comply. As we look at this, and I know that some people on the panel are more concerned about the advertising and the content that's being delivered to kids and whether or not it has to comply with COPPA, I think that the restrictions on what sites can do, and collection doesn't mean that they're grabbing the information and selling it to others. It means the ability to even post information or share it using email or any messaging technology. So it sounds like it means I'm collecting it and taking it, but it means that it can be shared even if nobody's watching. So those kind of restrictions on the ability of people to communicate, if they really aren't preteens, is a cost of, and an inappropriate cost. We just have to be smarter, and we're not. And I'm not here on behalf of the IEEE, but I am the Youth Privacy and Cybersecurity Advisor for the IEEE, and no one's bringing the standards groups to bear here. And we really aren't seeing the engineers and technology people talking to the public sector and talking to the policymakers. And if we're going to come up with solutions, we can argue all we want, but until those groups sit down together without media in the room and see if there's a way to address this, we're always going to be asking the same questions.
Hey, Don?
I want to leverage off something Perry just said. I sit on the board of the National Center for Missing and Exploited Children, and through my work with them, one of the things that we're always worried about is issues around child safety. To go to the question of what do you lose if you just immediately treat everything as though it's child-directed, you lose the ability to keep track of certain things and certain behaviors that, if directed towards a child, are particularly dangerous to the child on the part of the people who are engaging in the communications technologies.
And I'd like to add, if I can, the other thing that you lose is the ability for creators to engage with their audiences and with parents and people who really get into sort of a two-way street of feedback. YouTube is more than just a video platform. It's truly an engagement platform. And we see, all the time when adults are treated as adults and not as kids, when, we're able to reasonably identify that they're adults, that there are a lot of really, really valid and critical use cases. We have creators, family vloggers who have children with special needs, and they are communicating with an audience of families, of parents who have similar joys and challenges and issues in their families. And when you look at the comments and that engagement on parent to parent, you really, really see how important that engagement is. Science education creators, where a homeschooling parent may ask that science educator to do an experiment the next time in the video, and that two-way street leads to a next video that is really great not only for that family but for the entire community. So we're worried that when you treat adults as children, then you lose all of that, and that's just something that's so essential to the creator community and the impact that they're having on their audiences.
Okay, so I want to unpack something that's been raised about this idea of a distinction between directed to kids and attractive to kids. And I think a good case study is the TikTok case that we brought. When you think about intent, let's assume that they didn't intend for lip syncing to be so popular with kids, and at some point it became clear that that was an activity, and I think as Perry, you said, you can kind of morph and flip a switch. So I guess let me first of all ask, does everybody agree with our enforcement action stating that TikTok was, or does anybody disagree that TikTok is kid-directed?
I agree 110%.
Okay. Okay.
You know
So I guess the follow-up question from that is, so what obligation do app developers, device manufacturers, others who are creating these products, what obligation do they have to kind of continue to do risk assessments to make sure that they have not morphed or flipped the switch, as Perry said? What obligation should there be?
I don't know that it's so much an obligation as they shouldn't be running a business if they're not watching their audiences and their customers and the people they're reaching. So I think that it's included within their business operations to know where their audiences are and their customers. And if they're not watching that, they won't be around much longer.
Okay.
I would say, they obviously have an obligation, and there are so many signals that these companies get that if we want to give them the benefit of the doubt and they're not child-directed, but they just end up being child-attractive. I mean, when the Wall Street Journal runs an article about a 9-year-old influencer that just signed a deal with Nike on Instagram, and as Donna said, 9-year-olds are not appealing to 15-year-olds to sell sneakers. It's the 7-year-olds and the 8-year-olds that are interested in what a 9-year-old is wearing on their feet. That should be a signal to Instagram that the whole world knows that Instagram has a large portion of it, which is where children are on the site that aren't supposed to be. So I think there are so many signals that people on this end that I'm not aware of that I'm sure you get that your businesses are attracting a large portion of children. So I think there is an obligation to constantly be assessing: are we flipping from are we so child attractive that we're starting to attract children? And I don't think that should even be controversial.
So I think if we're going to build in assessing your business as it goes along, I think we need to be mindful of the fact that I don't think this is unique to kid-directed or child-attractive sites. I think it's businesses across the board have to constantly assess and reassess who their business and their target audience is. But if we're going to build it in as a factor in determining child-directed, then I think we need to be mindful, not just in this situation, but of all situations across the board as it applies to COPPA, is the cost of doing business, right? So we're talking with a lot of small app developers who don't have the infrastructure and the money to do some of this stuff. And I would ask that the commission, in reviewing the rule, think about the cost factors involved here and whether or not this is an easy lift or a hard lift for a company, and do we need to kind of tailor some of the factors for the smaller app developers versus the big conglomerates?
Don.
Donna makes a really good point there. I look at it this way: the law has to allow you to be terrible at business. And some of the things, the obligations to report and disclose and maintain and find out information about your audience is the law requiring you not to be terrible at business. And that isn't really the job of the law. And I mean, I'd like to hope that we're not terrible at business, but certainly I think that if the law it creates a standard that requires us to monitor and be good at business, that's not necessarily the greatest piece of statutory drafting I can think of.
But let me just kind of push back on that for a second. So if the law requires you to periodically assess your popularity with children, or, so if the public policy is that we want to make sure that sites that are directed to kids are policing their sites to make sure, to be informed as to whether they're directed to kids or not, why shouldn't that be a legal requirement, I guess, and Perry, I don't want to put you on.
Sure, I didn't want, Don
Hop on,
Reed, did
Perry.
you want to reply? Okay. I think that when we talked about advertising before, Donna and a few of the others are advertising centric, where we tend to be broader in cyber safety and as well as marketing. And I think when you look at how you're marketing your app, what you're saying about what you're doing. What did you tell Apple? What did you tell Google when you registered it? What do you tell people who may want to buy ads? What did you tell anybody who needs to know about it? Where are you advertising? All of those things, if you're doing that, that's an indication not so much of the advertising practices, but that you are directed at preteens. And then when you get to 12 to 14, it's a little tough, but you know that you're doing that and you're promoting it. If you're not promoting it, then you're bad at business, but you might be also out of compliance with COPPA.
If I can jump in, I would also, I think a lot of the points being brought up are really reasonable points, and I go back to the balance of the factors between content and context. And if you solely focus on audience, you kind of get into the sports use case again, where if there's a popular site, a popular match, popular game that's popular for everyone, or music videos that have large audiences, they're going to have a large kids audience as well, and that needs to be taken into consideration, but so too do the other factors of context and content. So I agree that these are reasonable points, and audience is important, but I also agree that you've got to have a true balance across the spectrum.
So Josh, and Jim, I'll get to you, but Josh raised an interesting example of the 9-year-old influencer on Instagram, and and certainly they have actual knowledge as to the 9-year-old, but the question becomes, okay, so then now they see this trend. At what point do they become child-directed? So Jim, you can answer that, or you can finish up the prior.
Yeah, actually, I was going to comment on that. But quickly, as to what you're telling your advertisers, that goes straight to intent, which I think is a really important factor. If you are intending to market the site to children, then you're directing it to children. I think that's a pretty easy answer. But then and repeat the question again.
So I was using Josh's example of the 9-year-old influencer on Instagram, and without naming particular companies, let's say you're a social media company that knows that you have large numbers of kids on your site, a large number of influencer kids. How should that play in as a factor in determining whether a site or service is child-directed?
So I'm going to flip this on its head a little bit and put my private practice hat on, because I've counseled a lot of app developers, a lot of computer game developers, a lot of television series producers, and I walk them through, and if I also at the end of that discussion say, oh, and by the way, you're going to have to go on an annual basis and reevaluate what you did before, or in case of Pokemon, did 15 years ago. And if you find ultimately that it's now attracting too many kids, you've suddenly flipped a switch. I mean, you've just raised the gate in terms of somebody wanting to get into that market. I mean, the garden walls have just shot up to the sky at that point, because now that's not even anything I can control in terms, it's not my intent to direct to children, but if suddenly I become too attractive to children, it switches the model. Boy, it's really tough to counsel somebody now. So yeah, let's get into this business, because it may get your knees cut off 2 years down the road.
So this might be a good time to introduce the hypo. this is kind of along the lines of what we've been talking about. Company D operates what it intends to be a general audience sports fan site, but it turns out that 25% of users are children. Should the site be considered directed to children? I think, Jim, you gave your perspective on that. Does anybody else have any views of this? Oh, sorry.
Sorry. I don't think it's a percentage. I think, I keep saying the penumbra.
What about 50?
Yeah, and I think, and it goes back to what James was saying, in that if you have kids, you're directed, you're expecting them, you're monetizing them, you're doing all these things because you know you have a substantial portion of youth market. If you don't care and you're ignoring them, they're just part of everything, that's one thing. But if you are making money in a space that is directed or deemed to be sufficiently attractive to kids that it's deemed directed at, there's a cost of doing business. And when you do business with kids, there's a higher cost of compliance. You have to make sure they're safe. You have to make sure they're secure. You have to make sure they're private. And we have always, as a community, recognized that kids deserve better protection than we as adults can get, because we can protect ourselves better than kids can. So if you're now benefiting because you have so many kids who are using it, yeah, there's now a different cost of compliance. It'll cost you more. Otherwise, age gate or create a separate site just for the kids so they'll leave you alone and keep talking to the adults.
Well, so it's interesting that I think some of the comments that have been made said that the percentage doesn't matter, but I think nobody disagreed with the TikTok case, right? And so at some point, TikTok knew, because of the large numbers of kids on their site, that lip syncing was an attractive activity for kids. And so how do you kind of distinguish this hypo from the TikTok hypo? Is it a context, or do you distinguish this hypo from the TikTok hypo? I guess not hypo.
Well, Musical.ly had actually put in age gating initially, and then they found out how many, I mean, they had actual knowledge of how many people had been on the site that they now recognized were under the age of 13. So they had proof at some point based upon what they did, which was maybe not a great decision on their part to
So
have
doesn't
done
that mean percentages do matter?
I think they do matter, and I mean, with Musical.ly TikTok, one of the reasons they put an age gate up is because we opened an investigation. And they said, we've got to do something, right? So that was the first step for them. But they still were not acknowledging the fact that they had a large, what we consider to be a large portion of kids. And really our assessment was really based on engagement in the app and seeing how many kids were there. You could just open the app and see young children. So it was clear to us that whether or not it was 25% or 35%, and quite frankly, I know that, a lot of companies use 35% as a threshold. And I agree that I don't know what the number should be, shouldn't be. Again, I don't know if there's a silver bullet here. But I do think that we need to use it as a factor. But the other issue is that all the other factors, I think some of them may be slightly outdated, or the way that we assess what children are appealed to is different, I think, now, 20 years later. Right?
Donna, did you also investigate or consider Snap and Instagram and some of the others?
We did investigate Snap. I could talk about that all day.
Oh, okay. All right, great. But, whether it's Musical.ly, TikTok, or the rest, I think somebody really needs to question the legal fiction of, we don't know we have a substantial audience of preteens.
Okay. Okay, so I'm sorry, Don, did you?
I was just going to say, look, I find sports examples very interesting in this context, because I think I might be the only person up here who's ever bought a Super Bowl ad. Maybe Malik has, I'm not sure. At a certain point, you don't think to yourself, I'm buying a Super Bowl ad, it's during a football game. The content of football we've deemed to be appropriate for children, notwithstanding that it's pretty violent. But nobody thinks that they're buying an ad focusing on children when they buy a Super Bowl ad. And you spend about $5.5 million to buy the space. So you want to make sure you know what your audience is when you spend that kind of money. I don't necessarily know that the idea that, sports are attractive to children. We all know that. But that doesn't necessarily mean that if you create a sports-related activity, you've created something that is child-targeted or child-directed.
Well, so I wonder if context matters here. So, we think about the Super Bowl and we think about sports, and as, one of the impetuses for the rulemaking was this idea that we have these new technologies like voice-activated devices and interactive TV. So, is watching a TV, I think somebody raised this point this morning, is, watching the Super Bowl on TV as a family different from kind of having a sports app that a kid could watch alone, or, a device, a voice-activated device that sits in a kid's room that talks about sports scores or things like that. So wondering if context matters. Josh?
I mean, yes, it certainly matters, and it doesn't just matter as context, it matters technologically. I mean, if we're watching the Super Bowl on, and everybody is seeing Don's Pokemon ad at the same time, that's different than if a child is watching sports on something and they're getting served a behavioral, personalized ad based on their experience that they've had on the internet and where they are and what the site knows about them. So that context in moving from, trying to reach everyone and hitting some children versus trying to hit a very specific user with very specific characteristics absolutely changes the entire calculus, I think.
Okay, well, so we've spent a lot of time on directed to kids, and before I turn it over to Peter, let me just spend a few minutes on actual knowledge. So one of the things that the rule says is, well, it seems as the rule says you have actual knowledge basically if somebody tells you my kid is on the site, you get a complaint saying, a kid is on your site. It seems like it's kind of directed to a specific kid. Is there something that we should consider about requiring an obligation to do more due diligence? We talked about the CCPA willful disregard standard this morning. Is that something that, that we should consider in revising the rule?
Just not to go twice in a row, but I mean, first of all, I think there's a couple of things to unpack here. First of all, there's what the rule says and what the new rule might say. But I also think that it's important to look at enforcement priorities and the effects that those have on changing how people interpret actual knowledge. Let me give a very concrete example. For years, YouTube claimed in its terms of service, as we all know, that it was for 13 and up, even though it was an open secret that there were tons of children on YouTube and that this was a place that advertisers went to reach children. On September 4th, you guys announced your settlement with YouTube. Now, there's another, there's a site called, a game called Fortnite that people may have heard of in this room, which try and find a 9-year-old who doesn't play Fortnite. Try and find a 10-year-old who doesn't play Fortnite. It's really, really hard. For 2 years, Fortnite said in their terms of service that they were for 13 and up because they didn't want to comply with COPPA and they didn't want to deal with all that stuff. On September 10th, 6 days after you announced the enforcement action, the settlement with YouTube, Fortnite changed its terms of service and now acknowledges that there are children on its site, now has a children's privacy policy. So enforcement actions go a tremendous way towards changing what companies actually know about children when they have a motivation to know what's going on.
So if I can jump in, there's a few things there that Josh brings up. One, I'll say that 5 years ago we built the YouTube Kids app, specifically to be the place for kids under 13 to go, and we did recently or earlier last month announce the product changes that we did to really treat kids viewing child-directed content, kids who might be unsupervised watching child-directed content on YouTube in a different way and an appropriate and right way. But I'll also add to your question on knowledge. We think that there's a big difference between actual knowledge and constructive knowledge, and we think that the actual knowledge standpoint and approach really is the right approach. There have been some who've said, well, Google and YouTube has really good machine learning. Can't you use that to identify accounts? And that's something that is flawed for a few reasons. One, machine learning, classifiers, it's not a perfect science. Two, it's also not used by everyone. I think that the bar would be set in a way that not all companies would be able to use that. And those are, some of the reasons why, we'd be concerned around kind of clicking in deeper with sort of actual knowledge or creating constructive knowledge. Last thing I'll say is that we generate actual knowledge all the time through the ordinary course of our business. And one thing that I'm not sure if this is a known, we haven't talked about it much, but every single week on YouTube alone, we terminate thousands of accounts on the platform that we get actual knowledge on where there might be a child who's under 13, and we think that that's the right approach.
Okay, Peter?
Thanks. I want to continue a little bit on Malik was talking about on the actual knowledge. And I mean, we did hear in the first panel, I think Laura Moy raised a concern about, and I'm talking about platforms that have user-generated content. They would be on the hook if they have actual knowledge that they're collecting information from the users of that child-directed content. And if there's a concern that the platform is going to bury its head in the sand to avoid getting actual notice, should we just be talking about a constructive notice standard?
I think that there are reasonable points being brought up, and there are reasonable signals to be looking at on how to inform actual knowledge. But the sense and the feeling that I have that we have is that that constructive knowledge in sort of the way that you described is a bridge too far that really could cross the line even on privacy, and their concerns around what might you have to do to create that constructive knowledge. The actual knowledge that we do generate through the ordinary course of our business is significant and meaningful. And as I mentioned earlier, every week we're terminating on just YouTube. It's bigger when you look at the broader company, but terminating thousands of accounts every week on the platform based on that actual knowledge. But this is one of the reasons why this forum is so useful, and we're so encouraged by it, because I do think that there are reasonable ideas, thoughts, and signals and points that we should consider as an industry.
I think, Josh, did you want to weigh in?
Sure. I mean, I absolutely think that a constructive knowledge standard is a better one for protecting children, and for exactly the reasons you say about the don't ask, don't tell mentality that is clearly developed at so many of the bigger platforms. Who knows what's going on with the smaller platforms? That's why my organization and many in the consumer advocacy community support the Mark D. Hawley bill, which would legislatively change the standard to a constructive knowledge standard.
Carrie?
I think that when we look at constructive knowledge, we also need to look at willful disregard. And so actual knowledge is a kid-by-kid basis, and constructive knowledge is you've got a section that's relating to students, you've got a section that talks about certain things, you get a sense because they tell you that they're in 4th grade. You have a whole bunch of people from a certain location. But I think that the more information you have, the more it falls into willful disregard. And even though we don't use those words in COPPA, it is used in California, and it really applies on, are you directed at kids? And it really comes back to that. So I think we need to look at that. How much do you know? When is it more than just constructive knowledge? When does it turn into, you really should be careful about this, because if not, you might be guilty of willful disregard.
Donna?
So I would suggest that it may make sense to take a look at risk and harm coupled with the knowledge standard, right? So maybe constructive knowledge makes more sense where there's an increased risk to the child versus actual knowledge and there's less of a risk to the child. I just don't think that one or the other, especially moving from actual to constructive for everybody in every scenario, makes sense.
Okay. Assuming that a platform, a general audience platform, has actual knowledge that some of the content there is going to be child-directed, but again, it's a general audience platform, and we've heard a couple things today about the nostalgia value of looking at things that might fall into the child-directed classification. Is there any context in which a platform could assume that the user of the child-directed content is actually an adult?
I think there are a lot of scenarios where the user or viewer of a child-directed content is an adult, which is one of the key reasons why we think it's so important to be able to treat adults when they're watching children's content, and reasonable measures are being taken to identify that as an adult. I'll share a personal example that comes to mind. A couple of years ago, I very randomly had the opportunity to interview the Reverend Jesse Jackson about his life and different things. And one thing that I did in that interview was I actually went onto YouTube and found a 40-year-old clip of him on Sesame Street doing the "I Am Somebody" speech to a beautiful group of diverse kids and young Jesse Jackson. It was an incredible clip. I showed him. He was speechless. For a man who has so many words, he was speechless when he saw it because it was the first time he'd seen it since he did it. And I think about, well, what if I was not able to comment to the other people who are interested in this clip and communicating about the history and the context of it, or even flash forward to now, Bruno Mars, let's say on Sesame Street. I like Bruno Mars, I'm an adult, and I'd like to be treated as one so I can comment with others. So I think that the notion of treating an adult as an adult, when we take the measures to identify that person as an adult, is really important. And there are a lot of use cases that I would say I would actually describe the YouTube experience as broken when you don't have that. It's not a nice to have layer. It's something that is central. I kind of think of color TV. If all of a sudden it became black and white, you would consider that television broken. And that's what YouTube is without that engagement for and with adults, with parents, and the like.
Malik, how many of your users are registered users who have been age-gated versus just people who are viewing YouTube without a registration account?
Good question. Don't have the answer to that. But I think where you may be going on that is that there have been questions that we'll probably talk about on the panel. Should a platform like a YouTube age-gate everyone? Is there some form of screen that we put up for all users? And the challenge there, and I think it's a very reasonable discussion and question to have, but I think that the challenge there is that YouTube also needs to be used signed out, logged out. There are so many use cases of YouTube where you might be someone who wants to view content for whatever private, personal reasons as an anonymous user without having your login credentials and information logged in. So it's a good point, but that's why we think that the logged out scenario is so crucial.
James?
Yeah, so I think this really tees up a critical issue here, and that is the more regulatory burdens we put on protecting kids, the more burdens we're putting on adults. And at some point, we are going to run into the First Amendment, and we got to recognize that. And certainly in the context of discussing GDPR and other responses, we do have a First Amendment here. And COPPA, as it was created in 1998, and as Commissioner Phillips noted, was a fine line of First Amendment dancing that got it right. But if we keep pushing this and we keep putting more and more burdens on platforms to age-gate everybody, now the rights of adults who have nothing to do with children are now impinged. And at some point, we're going to buck up against the First Amendment, and there's going to be a real challenge here that we're going to have to face.
I understand. But I think in the platform context, and Malik, I liked your example of the Sesame Street episode, but I mean, I think it's fundamental to COPPA that we look at the nature of the content, and if it is child-directed, we have a default. We assume it's a child visiting there. So I guess my question was, are there any layers you can build in that would allow you to overcome that presumption? But even with your example, I don't know how you shouldn't have treated you arriving on the Sesame Street video as a child.
Well, I think in that scenario, the problem with treating me like a child is that I wouldn't be able to engage as an adult. And maybe another scenario is the science creator on YouTube, the science educational creator who is making great how-to and physics content for an audience. Imagine a classroom that goes beyond the borders of their wall. And there are a lot of scenarios where a homeschooling parent asks that specific creator to do something next. And the engagement with that adult, with that parent, actually has a positive impact on what the next video that created is going to be. And oftentimes, you'll find in the comments section on family vlogs that there's a community. It's not just creator to the viewer. It's viewers. It's human beings who are connecting with each other on the topic of the video or the channel. If it's a creator, a family creator who shares that they've gone to marriage counseling, for example, and then you look into these are real examples, you look at the comments, there's a back and forth on parents on this content that in some scenarios may be deemed child-directed, but with adults who are treated as adults specifically, you see it really be a valuable component to the experience. More than valuable, just central.
Did anyone else want to weigh on this? And then otherwise we'll, okay.
Are we suggesting that if parents are trying to engage with their kids in an online environment similar to what Malik is talking about, that we're now assuming that they're all children? I mean, so we've had this conversation as a safe harbor with you all, that if something is downloaded and the target is preschool kids, right? They can't read. The presumption is that it's the parent who is engaging, who's downloading, who's creating an account, if possible, whatever it is. So I think that to make the presumption that if you visit something that is child-directed, the presumption is that everyone's treated as a child, I just think it's inappropriate. I think that we need to have some sort of other tests involved, because you have a lot of parents who I think are looking at the content before they want to allow their children to view it. So we need to allow for that. We need to allow for parents' engagement before their children do anything.
But say you do that, and you collect data from in this case, the parent that arrives there first. Are you suggesting then that when they hand it over to their kid, all bets are off and they can collect from the subsequent users?
I guess the question then becomes, what data is being collected? And I think that that's a case-by-case situation, right? What data is being collected? Is it just an IP address? Is it device ID? What data is actually being collected?
I would think that the personal information as defined under the COPPA rule would be my assumption.
Okay, so we're assuming that PII is being collected. But if it's a child, then haven't we already engaged some other process beforehand to do that?
We heard from Dr. Rudetsky this morning that these, with the preschool apps, they're frequently not being pre-vetted by adults. But I would also say, the COPPA says that this is what happens with child-directed content. And so if industry wants to make carve-outs for adults viewing child-directed content, I really think the burden is on industry to demonstrate how often this happens, so we can, because we can't talk about trade-offs and potentially trading off children's privacy based on a few, and genuinely touching anecdotes. I don't want to downplay them, but we can't make policy on that. We can't make rules based on that. So having an understanding of what industry knows about how often adults are viewing this child-directed content and what technological solutions they would propose for carve-outs for those adults. But child-directed content is the heart of COPPA. We spent a lot of time talking about the general audience and the mixed audience, but the child-directed, that's what COPPA is about. And so it seems to me very dangerous to start talking about carve-outs for adults viewing child-directed content without having much more knowledge about what those look like and how often they look like, and how we can be sure that on repeat visits it is that same adult, and now that the device hasn't been handed to a child.
If I can jump in, I think there's some good points there. There are a lot of I know creators who are watching this stream right now. Some in the audience here who are happy that this process is underway, because I think one of the big values of this process, Josh, to your point, is there's a need to get more intel, information, and feedback, and I encourage the FTC to really open up the tent to be inclusive of creator voices who have some of the anecdotes I've shared, but even more, and can really share how central, how critical this is. I'll share one more anecdote, a personal one that I did. I tried to be a creator off and on, but about a year ago I on a board of a nonprofit, LA Makerspace 2-Bit Circus Foundation, and we do STEAM education in libraries and schools. I created a video to try and help to teach kids how machine learning works, and to try and teach caregivers and librarians how to teach that, and created a fun video that has, candidly, two audiences. One is, hey, future, people of the world, here's something that you should care about, and here's, a very simple way to think about it and learn it. But the ultimate audience was actually teachers in the classroom, caregivers, parents, librarians, to take this project and then actually unpack it in a more robust way for kids, all in one video. The adults who watch that should be able to ask me questions about, well, when we're doing this project and we have a question, what's the answer? And the kids who watch it should be treated as a kid. And the anecdotes go further than just a few examples. It's really a robust, very central experience on platforms like YouTube.
Sure, Perry.
We've done a terrible job with kids. We treat COPPA, it took them 2 weeks from the time COPPA became effective to understand that they had to be 13 or older. And I poll 10,000 kids a month in person when I talk to them, and the average age that they claim to be is 24, because it's not so old. They used to say 96, and I'd tell all my clients to screen for any 96-year-olds, and if they could still type, it's okay to leave them on. But we need to recognize that the kids are very good at this, and so it's punitive as far as they're concerned. If they say they're under the age of 13, they can't do things. We in the nonprofit, I'll put my nonprofit hat on for a moment, we in the nonprofit community are doing a bad job. There used to be something called the ad bug a million years ago it was a little bug, and it came from the label company, whatever the big label manufacturer was, and it would help kids identify ads, and the kids would click on them to show how much they knew. Well, maybe if we can give them something beneficial, if they self-identify as under 13, that may solve a lot of this with something that maybe they can't do the full-fledged communications, but they can do something else that's interesting and fun in connection with how they're engaging without you collecting it. So they are self-identifying as under 13. And it's in some ways more effective than age gating because they know to lie there. And if you can come up with something fun for them to do that's age directed that might be very interesting, it might be a way around this.
Well, maybe that's a good segue into the mixed audience exception. I did want to talk a little bit about that because, and that concept does have kids self-identifying, but the mixed audience sites are sites that are child-directed, but they don't target children as their primary audience. And this was added to the rule in 2013, and the idea was to, if you fall into this category, you can age screen and you can treat kids who identify as under 13 in a COPPA-compliant way, and the rest of the audience as 13 and over. When we announced this proposal, some commenters were concerned that this was just going to be a big loophole that undermined kids' privacy, kids were going to lie. And then other commenters worried that it would significantly expand the range of sites that would be covered by COPPA. Sites that otherwise would have been considered general audience are now considered mixed audience, and they have this additional obligation. So I just want to open it up. Have these concerns borne out? What are you seeing with respect to mixed audience? Is it working?
So I've worked with a lot of companies who have utilized the mixed audience environment. I'm a fan of it. I think it works, but it's also a costly thing to do. You're essentially creating two products in one, right? But I think the reason that a lot of companies like it, that do use it, is because children are not lying, right? So under the previous COPPA regime, when kids saw an age gate, they knew that that was intended to block them out, and they would lie about their age. In a mixed audience environment, the child is still allowed in. They don't know that they're missing anything, right? So they get what I call a vanilla environment on one side. If you're under 13, over 13, you kind of get all the bells and the whistles. So I'm not a fan of age gates, but I think in the mixed audience realm, it does work because it's not about blocking the child, it's about allowing the child in. I think age gates that block users out, and we did a case with SNAP with regards to, non-COPPA compliant age gates, and we've taken the position that these types of age gates, we're hitting a low bar, right? If the low bar is just making sure you have a COPPA compliant age gate, that's not enough. I think that we need to talk about what's happening behind the scenes. Because if you have a child at home who has all of a sudden learned how to crawl over the gate that you have leading into the kitchen, you don't just keep building a higher gate. What you do is, the child's getting in, so now you've got to take all the knives off the counter, you've got to lock all the cabinets, you've got to plug up all the outlets. You increase the security, right? You don't just keep building higher and higher age gates. It doesn't work that way. And I think we need to take a look at what age gates work and what scenarios they work. If we're going to continue to block children out, it's not a matter of if they breach an age gate, it's when they breach an age gate. A mixed audience environment allows children in without having to lie.
Any other thoughts on mixed audience? Maybe I'd love to hear from Don, perhaps, and how Pokemon has dealt with that.
Sure. I mean, we've, having, as I've mentioned, the nostalgia-based audience as well as the kid-based audience, we've got a lot of experience with age gates and age gating and parental verifications around them and all of that thing. We use a technology that's been provided by a company called Veritad that it basically takes you take the last 4 digits of your social security number, add them together, and put that sum in an API window that's called, and that sum authenticates you, which is a great piece of technology that we love. We pay about 35 cents per API call, but we think that's a great way to authenticate people in. We've found that the mixed use environment, the delivery of the experience to kids and who haven't been able to get parental authentication and parental verification is a great benefit. It was a good piece of creative rulemaking from the commission, and it's allowed for people to experience things that they might not have otherwise had a chance to experience, that they might have felt, well, now I have this barrier, like Donna describes it, sitting in front of me, and I need to go deal with getting past this barrier in order to be able to access this thing that I want to access, rather than allowing for delivery of something that the child wants to see in an environment where they're not being required to authenticate to see it.
And I think, VPC, obtaining verifiable parental consent is a hurdle, especially in the mobile app environment. We're not seeing a lot of it because it's difficult to implement. I mean, I would argue that VPC may actually be a misnomer. Are we really verifying the parent and child relationship? I mean, outside Email Plus, where you have to give a child has to give their parents' email address, do we really know outside of that environment whether or not this is the parent of this child? And that's what we're trying to figure out here. And I would suggest that we try and figure a way to kind of roll that back and look at it, because we're authenticating that someone's an adult, that they're over 13. But we're not doing anything about determining whether or not that's the parent of this child.
Or the parent with legal authority over
Right.
that child.
Right.
Well, just sticking with this topic for a minute longer, we have heard from different stakeholders that there's some confusion about when somebody is mixed audience as opposed to general audience, you know, maybe what the threshold is. Can you talk to what guidance you give in how you make that determination?
I mean, part of it is taking a look at all the factors, right? And also talking to companies about, well, let's look at your marketing tools, right? Let's look at how you intend to market this. Who is your target audience? Who's your intended audience? A lot of companies have products where they're like, this is our main audience, but we anticipate that we may get a large number of children. If you anticipate that, my advice to you is that you create a mixed audience environment so that you can create a safer environment and that you don't have to go through the process of doing VPC, but you're allowing all of your users in to engage in your product.
The only thing I would add to this topic is that on the topic of mixed audience, we believe that the spirit of that exception is right, but we would also encourage the FTC to consider expanding it as well to child-directed, in that, you know, treating adults as adults when they are watching kids' content, and there's reasonable measures that are being taken to really identify that as an adult would be a good expansion and a good way forward.
Okay, well, we've got just a little bit of time left, and since this is a rule review process and we're sort of looking at where COPPA is now and maybe where it should go, I'd like to give each of the panelists a shot at a final word, and if you could, very quickly, if this is possible, describe what you think is the most powerful impact of COPPA over the past almost 2 decades, and what, if anything, you would change about COPPA. So we'll go right down the line. Perry, you can start, and briefly, please.
Well, 20 years ago, nobody was thinking about kids' privacy. Only the insiders. And COPPA took a very brave stand. After the FTC said, get your act together, we don't want to do this, and everybody ignored them for so long. So the best thing that did was raise the appeal of addressing kids' privacy and recognizing that these are serious issues. The one area I'd love to see improve is doing a better job. I think that the FTC has done extraordinary things with some of the new enforcement issues, but I think maybe some of the watchdog groups, I think that you're part of that, and I guess we're part of it. We always were at Wired Safety. Some of them look at it and try to help you understand when things are going wrong, so we can be the eyes and ears online. Because we all have the same thing at stake. We care about kids, and so I think that that would help.
Great. Lightning round. Malik?
All right, lightning round.
Sorry.
So, you know, I think that the past 19 years, I think that COPPA really added, you know, so much to the mix on meaningful protection for kids, putting parents in really more of a driver's seat where they belong, and the rule has evolved over time. In terms of areas of improvement, I think it needs to continue to evolve to reflect some of the realities of today's world, and topics that I've hit on, like treating adults as adults when they're on kids' content, and really engaging with their audiences. The other thing I'll say, because I think that there's a topic that we didn't click into too much, is really thinking through as you move forward in the rulemaking on the immense value of content creators and developers. You know, what this next generation of creators are doing, who are empowered by platforms like YouTube that have really given small businesses large voices and an ability to really change change people's lives for positivity is really extraordinary. And I encourage the FTC to click into that more and see what's at stake with some of the decisions it makes around rules, because I think harm can be done to the very constituent, the very group that we all care about on this panel when that's put at risk.
James?
So when we look at COPPA, we often forget the second P in COPPA, which is protection. And I think we need to go back to legislative history and look at what we were really protecting kids about. And first and foremost, it was predation. It was sexual predators. And if you look at the hearing, what Robert Potofsky, the FTC chairman, said at the time, that's what we were worried about. And I think we've done a great job, COPPA, in that regard. COPPA as part of an overall enforcement on child predation. But my concern is I fear we are moving into taking a protection statute and turning it into an anti-advertising statute. And I think if we do that, as Malik said, you're going to harm an ecosystem, you're going to harm the marginal players, and all you're going to be left with are the big tech companies who can afford the regulatory overburden of this. And I think we've got to be really careful about that.
Thanks, Donna.
So I think that what COPPA has allowed, and I agree with what most have said here so far, is that it's allowed for, through safe harbors, a great self-regulatory model to show that there is a way to self-regulate in this area. And to that end, I would ask that what I'd like to see moving forward is increased scrutiny over how safe harbors operate. I think that we can be more transparent. I welcome the transparency. I welcome more scrutiny. We have nothing to hide. And I think it can only help the environment. The problem is that between the 7 safe harbors you have in the United States, we may represent probably less than 10% of the entire market. So there needs to be a really increased effort with regards to educating consumers and businesses about COPPA. I think the FTC should take the lead on that, and I think safe harbors should be obligated to follow that lead.
Great. Josh?
So I think in terms of what COPPA has accomplished, first of all, it's really the only law we have to protect children online, and that's important. We have fewer regulations around how you can advertise to children online than we do on children's television. So we see things like influencer videos being very commonly aimed at children on the internet when they wouldn't be allowed to on children's TV. So it's important to have some restrictions on marketing. We have, we have the data being used to fuel the most powerful persuasive technologies we've ever had. And to some degree, COPPA has kept children out of that somewhat. But increasingly it's not. And what I would love to see from the commission, we're starting this process 3 years early. So if we're doing a special rulemaking 3 years early, I hope that we would take a little broader stance than maybe some of the 25 questions that you asked in the notice, and really ask, really dig into what's going on. What does industry know? How is this data being used? When we're talking about a mixed audience site, what do the sites know about a child when they're arriving? What are all the signals that they're bringing with them about that individual child? There's so much that the industry knows that I don't know, and frankly, I don't think the commission knows. So I would hope, since we're opening up the can of worms 3 years early, let's open the whole can, and let's use that 6B authority to really understand what the industry is doing so we can make rules that aren't just based on speculation.
Great. And final word.
Lightning round. Donna stole my thunder. I think one of the greatest legislative creative aspects of COPPA is the safe harbors. As somebody who sits in industry, they are very useful to us. I've been working with Donna for years. I've followed her through her career travels, and it's been fantastic having somebody who can advise us on what we need to do to be correct. I'm not afraid to sit inside the Federal Trade Commission's house and advocate that they should get more budget for enforcement. I think more budget for enforcement for the FTC would be a great idea. More enforcement activities. It's always easier to be a good guy when the bad guys are getting kicked in the shins.
Great, thank you. And thanks to all the panelists.
Thank you.
Thank you.
Shirt, come on, nobody commented on your shirt.
Right? I wore my very best blouse today.
I started advising.